In this video, we will continue our examination of the scope of UCC Article 2 by addressing the difficult problem of mixed or hybrid transactions. By mixed transactions, I mean transactions or contracts that involve the sale of goods, but that are not solely for the sale of goods, because the transaction or contract includes some non-goods component. Most commonly, the non-goods component is a service. Specifically, the party's contract contemplates the seller of the goods will also provide the buyer of the goods with some service ancillary to the goods themselves. Consider, for example, a contract for servicing and maintenance of an aircraft. As the parts of the airplane wear out or become defective, the service provider might be required to replace and install new parts on the plane. These new parts are clearly goods, but the contract also involves installation and maintenance works, that is, services. So, in this kind of transaction, does Article 2 apply, or should the common law of contracts govern? Before 2022, the UCC was entirely silent on this question. To fill the gap left by the statute, courts developed two different tests to answer this question. The test used by the vast majority of jurisdictions that have addressed this question is the predominant purpose test. Under the predominant purpose test, the principal inquiry that the court engaged in is, what is the predominant or primary purpose of the contract? Was it for the sale of goods, in which case Article 2 applies to govern the parties' relationship, or was it for services, in which case the common law of contract governs? To make this determination, the court might weigh various factors like the relative cost of the goods to the non-goods, the nature of the seller's business. Is the seller primarily engaged in the sale of goods or primarily engaged in the provision of services, as well as the party's own description of the transaction? Was the transaction a services contract or a sales contract? And like any multi-factor based test, because no one factor is dispositive, the predominant purpose test has been criticized because it can be difficult to predict ex ante how a court might rule on the question. In response to this criticism, a minority of jurisdictions adopted the Gravamen of Action test. The Gravamen of Action test is the leading alternative to the predominant purpose test, although it has been adopted by only a couple of jurisdictions. Under the Gravamen of Action test, the principal inquiry is, does the claim or dispute between the parties relate to the goods or the services component of the contract? Does the plaintiff's claim relate to the goods portion of the contract, in which case Article 2 applies to govern the dispute? Or does the plaintiff's claim relate primarily to the services portion of the contract, in which case the common law of contracts would govern the parties' dispute? In the year 2022, the ULC proposed amendments to Article 2 to finally address the issue of mixed or hybrid transactions by adopting a version of the predominant purpose test. But it is important to emphasize that the 2022 amendments have not yet been adopted by every state. So, many states still have a version of Article 2 that does not expressly resolve the issue of mixed or hybrid transactions. In those states, presumably, the existing common law tests still apply. So in practice, it will be important for you to look at your state's version of the UCC to see what it actually says. But because our focus in this course is on the official version of the UCC, let's see how the 2022 amendments address the issue of mixed transactions. Let's start first with Section 106, subsection 5, which defines hybrid transactions to mean a single transaction involving a sale of goods and the provision of services, a lease of other goods, or a sale, lease, or license of property other than goods. Basically, it defines a hybrid transaction to involve a sale of goods and something else, the provision of services, the lease of goods or real property, or perhaps the license of intellectual property. So how does Article 2 apply to these kinds of hybrid scenarios? We have to look back to Section 102 of Article 2. Subsection 2 of 102 builds on the predominant purpose test that was developed at common law. Specifically, the statute gives us a two-part test. Under subsection A, if the sale of goods aspects do not predominate, then only the provisions of this article which relate primarily to the sale of goods aspects of the transaction apply. Stated differently, if the sale of goods was not the predominant purpose of the transaction, then Article 2 still applies, but only to those provisions or parts of the transaction that involve the sale of goods. Article 2 would not govern the other parts of the transaction, the provision of services, the license of IP, or whatever else was involved. Subsection B then provides that if the sale of goods aspects predominates, then this article applies to the transaction, but it does not preclude the application in appropriate circumstances of other law to the aspects of the transaction which do not relate to the sale of goods. Stated differently, if the sale of goods was the predominant purpose of the transaction, then Article 2 governs the transaction. But subsection B still leaves open the possibility that in appropriate circumstances, a court might apply other laws to the non-goods aspects of the party's deal. Note, whether a transaction falls into subsection A or subsection B still requires us to first determine whether the predominant purpose of the transaction was for the sale of goods or for something else. And the statute gives us no guidance on how to make that determination. Presumably, here is another instance where the common law would be used to fill in the gaps of the statutes. The same factors that the courts use under the common law predominant purpose test to determine whether Article 2 applied would also be used under this codified version of the test to determine what law applies to the party's deal. So in some cases, we may still have the same difficulties determining ex ante, that is, before a dispute is litigated in court, whether Article 2 applies to a particular aspect of the party's contract. So, to summarize, there are no perfect answers to the question of what law should govern a mixed or hybrid transaction. That is, a transaction involving both the sale of goods and some other non-goods component. The 2022 amendments to Article 2, which have not yet been adopted in every jurisdiction, attempt to resolve the question by codifying a version of the predominant purpose test, but that multi-factor test does not always give us a clear result. In the next video, we will conclude this week's module by examining how other state and federal laws, in particular the CISG, limit the scope of UCC Article 2.